And this matter is before the court at this time on defendant's motion for summary disposition pursuant to MCR 2.106C10. So at this time, I would invite counsel to place your appearances on the record.
Good afternoon, Your Honor. Daniel Groves on behalf of the plaintiff, Mr. Charles Palmetier.
Good afternoon, Your Honor. Nick Rizzo here on behalf of all defendants.
Very good. Thank you, Mr. Rizzo. All right, Mr. Rizzo, this is your motion, so I'm going to let you lead off. And, it seems to me, having reviewed the motion, it's entirely based on the notice question. Isn't it enough when the plaintiff says, hey, look, it was snowing and I slipped and fell on slush at an entrance of the defendant's store during the business hours that we have constructive notice there?
I don't think so, Your Honor. Under Michigan law, speculation regarding the duration or existence of a transient winter conditions insufficient to establish constructive notice, and it certainly doesn't give actual notice. It's as simple as this. The only deposition that occurred is plaintiff's. Plaintiff, he's headed into the D&W store to return a plant. He walks the same direction into the store as he does on his way out. He encounters no obstruction, obstacle, hazard on the way into the store. And on the way out of the store, he slips on what he describes as slush. Plaintiff has no opinions on how long the alleged hazard was there. It was snowing. I've reviewed plaintiff's. I was going to tell the court I have nothing to add to my brief except for the fact that I've reviewed plaintiff's reply and plaintiff rests on the fact that my client was there plowing when this occurred, and somehow that makes my client unreasonable. They were there plowing because, pursuant to contract, it was snowing and there was at least 2 inches of accumulation. So they were plowing when this occurred, and how anything can be perceived separate and apart from all of my clients acting reasonably under the circumstances, I don't know. The record is devoid of any notice whatsoever of this alleged hazardous condition.
Well, I'm glad you mentioned the plowing because that was the second part. Okay, so I guess if you take the plaintiff's deposition testimony at face value, well, it would be possible that he went into that store. There wasn't any snow or ice on the ground. It accumulated, while he was exchanging or returning the merchandise that he'd purchased. And by the time he went outside, there was an accumulation to which no one had any notice, including plaintiff, and he slipped and fell. But the second piece of that is the, seeming admission, I think, in disclosures that the contractor, T. Meyer, was present and plowing there because the contract specifies a certain amount of accumulation. I think it's 2 inches. Doesn't that say, well, there's another piece of information from which jurors could infer that it had snowed, in conjunction with plaintiff's testimony, that because I think his testimony was it had snowed prior to going to the store. He couldn't recall if it was snowing while he was there, but it had snowed prior to, and that he was aware of some snow on the ground. Doesn't that kind of put the good housekeeping seal of approval on his testimony that there was snow on the ground?
Well, it's uncontested that there was snow on the ground. It was snowing. And as a result, my client was there plowing. That's why I attached for the court's review those 2 unpublished decisions that I thought were directly on point. I mean, in general, general awareness that it's snowing or that ice may form while it's snowing is insufficient to establish any notice whatsoever. Again, it's snowing. It snows often here in Michigan, and what you're supposed to reasonably do under those circumstances is hire a professional to remove the snow based off of whatever agreed upon terms. And in this specific case, it was 2 inches of snow. It's February 15th or February 14th, and it's snowing. And as a result, one of my clients is there removing the snow. There's nothing that my client because of the fact that the snowplow was there, there's nothing that they could have otherwise done to avoid this. And again, by plaintiff's own admission, he successfully navigates into the store, walks the exact same path out, and that's when he encounters a problem. And those two unpublished decisions that I attached both stand for the proposition that if no one can determine how long the alleged hazard is there, um, I don't know how you can be put on notice of the alleged hazard.
Okay, and now one of the decisions you attached, I can't recall which one it was a black ice decision in that, that might create a slight difference because I guess the idea there is that the black ice, of course, can form, even if you've taken all those precautions and plowed or shoveled, you might get black ice and it might not be visible, to a person, a person who could do something about it, salted or remove it, as to give them notice. Isn't snow falling from the sky a different situation?
I don't think so, Your Honor. Again, I mean, I think where you get into trouble in these types of cases where it was when it snows and the snow's not removed in a reasonable amount of time. And here we couldn't be more reasonable. We're actually plowing while it's snowing. You can't do anything else. There was zero time lapse between, the alleged hazard accumulating and us mitigating that risk.
All right, and I guess that brings me down then to the plowing contract. I did notice one nuance in there that says, within 2 hours of the store's opening, this gentleman's going in there at 10 in the morning. So I presume, that's a couple hours at least after D&W opened, and the plowing is then occurring at that time. Um, and it has a provision in that same contract, I think, for shoveling where it says, well, and you should shovel the walkways as well. And those aren't 2 inches, those are 1 inch. What about the argument that, well, do you know why didn't this guy get out there and shovel the walkways first and then go out second and plow? Or is that, again, just too speculative?
It's just too speculative, Your Honor. And again, it belabors the point. We have zero evidence of the amount of snow that was there, separate and apart from it sounds like the snow plowing company was there pursuant to contract. That the plaintiff offers no testimony whatsoever about how long the alleged hazard was there, or what specifically the alleged hazard was. He described it as like slush, implying that perhaps something that just melted. I mean, he did not encounter this on the way into the store. And so I don't know how any reasonable defendant would have notice of the situation if it wasn't encountered by, the person who was immediately just transversed over it.
And did he say he went in through the same exact door, same exact route?
It's my understanding, yes, he was making a return at the main entrance.
Okay. All right. And so I guess in your best case scenario, that 2 inch accumulation was hit sometime while he was, um, arriving at the store. Perhaps the plow people are coming out. They had started plowing. Here, D&W is doing everything it can to, make a reasonable effort to clear the snow. And nonetheless, while all that's going on, he walks out, and for unknown reasons, having negotiated on the way in, something causes him to slip and fall on the way out. And, you're saying just too much of a reach to say that had to be the ice and snow. He does say he slipped in the slush. To me, I guess slush is, kind of inseparable from ice and snow. Does the fact that it's slush mean anything different?
I think it bodes even more in our favor, implying that it was temporal in nature.
Sure, it's starting to melt. Maybe it was on its way out.
And again, the record is devoid of any timing about any hazard whatsoever. All as the record establishes is that my client was there mitigating the risk as it was snowing, the alleged risk. And it's a reasonableness standards. And I again, the record is devoid of any allegations that my client waited. It's not a situation where my client waited too long to snowplow. They were snowplowing as this was going on.
As the
Yeah.
snow's actually falling. And from all everything we can tell, the same snow that they were plowing was the, same accumulation that the plaintiff slipped and fell on.
Yes.
Okay, all right. Well, let me turn to Mr. Groves.
Good afternoon, Your Honor. There are several points I want to bring up that brother counsel just mentioned, but let me first start that plaintiff relies on our brief submitted. Further, plaintiff concurs and agrees with the court wholeheartedly in the questions you were asking defendant. What comes to mind immediately before I start making my arguments is brother counsel just said there's nothing. He used the infinitive term, there's nothing that could have been done, which is absolutely not true. Nothing. The store was open during business hours. The store had a choice. If, Your Honor, somebody at that store, whether owner or employee, had to open those doors. They had to go inside. If you look at Plaintiff's Exhibit 4, those show the parking lot and how much snow, slush, ice was there when my plaintiff fell, right? That didn't happen within 5 minutes, 10 minutes, or even an hour. The National Weather Report for that specific area shows it started snowing the night before.
Is
And
that in evidence in the case?
we sent it to defense counsel, but I don't believe it was added to this response. But we did send it to defense counsel showing the snowfall began the night before, and it was predicted by the weather committee that there would be up to 2 to 3 inches, it said, and they got about 2 inches at that store. So there was, when we talk about notice, first of all, plaintiff relies on the fact that we understand open and obvious is no longer part of what this court has to look at, but it can consider it. But what was the whole open and obvious about? You live in Michigan, you know it snows, there's 4 seasons. If you live in Michigan, you should understand, I mean, that's open and obvious, it snows. And it snows, and snow creates ice, black ice, slush, and any derivative of snow, water, and ice is what's created. The other point I wanted to make about brother counsel's argument is that he said he traversed the area going into the store and then used the exact same path exiting it. I would assert to this court it would be nearly next to impossible to do the exact same footstep exit. The entrance is wide. Again, if you look at Exhibit 4, you can see not only how wide the exit or the entrance is, how big of an area, but you can see the snow. Your Honor, you can see the snow right there. And his wife took these pictures after he fell. These are not the next day. These are not before. This is right as it happened, which leads to the next argument that this court brought up that plaintiff concurs. Brother counsel said there's nothing that could have been done. Well, the contract says they could have shoveled the sidewalk in the entrance first because that's the most main common general area used to enter the store. That's the path. And they're deciding to plow in the back of the parking lot first. Plaintiff's initial argument was going to be, how can defendants, both, plural, how can they argue there was no notice when their person that they hired to do this was there? He was there trying to remedy the situation. And as far as nothing could be done, somebody at that store had to make the decision to open those doors with the snow there. They could have said, no, let the plowing be completed. Let the plowing so nobody gets hurt. Then we'll open at 10:30 a.m. They didn't make that decision. The contractor that came out to plow could have made the decision as it was snowing continuously from the night before to get there earlier. But Your Honor, respectfully, that's a question of fact. Maybe they had other contracts that they had to plow first. Maybe there's some other reason they didn't go to that store first. Who knows? That's a question of fact for the jury. But even if this court didn't consider a question of fact for why the snowplow company showed up when they did, which was after the store opened, then it's still, plaintiff asserts, it's still a question of fact between the communication and the contract between the two defendants on what is reasonable in that contract communication for the safety of the public. That's a question of fact for the jury or the trier of the fact, this court, to decide if the communication in that contract is reasonable. This court has already pointed out that there are specific paragraphs and counterparts to that contract that said the sidewalk at 1 inch should be done. Plaintiff relies on those exhibits number 4. And Your Honor, respectfully, if you wish for us to update our MSD with the report that we did provide defense counsel with, the weather report, we can do that. But it was snowing the night before. It had snowed all night, and it was continuing to snow. And that area was left unattended enough for plaintiff to fall. And I guess counsel would be more convinced if there was some other action taken that brother counsel says, no, there's nothing else that could have been done. But the lot could have been plowed earlier. The store could have been closed until it was safe. They could have plowed the front entrance first instead of last. There's too many questions of fact. And as far as notice, you don't need specific notice, constructive notice. And as the court pointed out, the snow was already there in the pictures exhibited, and it was falling from the sky. That's notice enough in Michigan. So again, we rely on our brief, and I would be happy to answer any questions this court may have, sir.
Well, and I think Mr. Rizzo makes a valid point in that, okay, I get notice it's snowing. I bring my plow crew out there and they begin remediating it. And I guess, what other sort of response to that notice can we expect premises owners to take? All they can do is either, begin plowing and shoveling themselves or get their contractor going on it. So once that, otherwise the notice becomes kind of self-defeating. If I hire someone to do it and they come out to do it, well, then it's assumed that there's going to be enough snow and I've got them there doing it. I guess his question, and the dilemma he throws up there is when all of that happens like it's supposed to, the corrective actions being taken at the same time the accident occurs, what more is a premises owner to do with their notice? In other words, other than begin to mediate it, remediate.
The premise who has invitees coming into his public store, and we know, Your Honor, invitees have the highest standard of care. That same owner who engaged in a contract knows, simply by entering into the contract, he knows the liability for an invitee. So if he engages in that contract and he can assess, he knows because he entered in the contract. If he can assess at the beginning of that day, that store was already open for quite a period of time before the fall happened, then absolutely correct, Your Honor. He himself could have at least shoveled the front part of the entrance of that store, the only entrance to that store, yet he still, or someone still opened those doors and said to the invitees, come in, and left the snow and the ice and the slush there. They could have remedied it themselves as another possible remedy, which goes back to the question of fact. As far as the two case laws that brother counsel gave to this court, and I know, Your Honor, you already surmised one, neither one apply in our opinion, because in this particular case, defendant has already acknowledged that they understand the snow was there. They've acknowledged, and brother counsel even said right before the court in this hearing, we're not negating the fact that the snow was there. We know that the snow, the ice, the slush was there. Your Honor, it's just not foreseeable to say that from the time the plaintiff entered the store and returned one product, that it snowed 2 inches, that it snowed even 1 inch. It's just not feasible. And the weather report supports that. But even if we don't include the weather report, snow coming out of the sky and the accumulation in Exhibit 4 shows it had been there. It was there. It doesn't happen in that much snow does not happen in a short period of time, less than a half an hour. But Your Honor, to specifically your question, yes. Other remedies, by entering into a contract, the liability, and he could have shoveled the front entrance, as well as got out there and said to the plow company, our contract says get the sidewalk done. Or there's so many remedies that we believe it's a question of fact to see if the jury believes it's reasonable on what did occur and did not occur.
All right, Mr. Rizzo, I'll give you the last word here, and then I think I can make a ruling on the matter.
Your Honor, I'd rely on the extensive law cited in both my motion and brief. The record is devoid of any evidence of notice whatsoever. It's entirely speculation. And then I'll just rest on plaintiff's actual testimony, which I highlighted on page 7 of my brief. It was almost like slush. I didn't have any problem walking in. And when I came back, when I went down, when I walked back, and all of a sudden I just slipped. Question, okay. It was almost like slush just came out and then I went down. I don't know how that establishes that my client should have had notice, and I'll leave it at that.
All right. Well, the question before the court is a slip and fall that occurs on a sidewalk area outside a D&W store. It is approximately 10 in the morning, and the plaintiff who was injured in the fall testified that he parks in a handicap spot and gets out of his car and walks on that sidewalk. And in fact, I think pushing a cart with the plant he wanted to return when he's going into the store. It doesn't appear to be any dispute here factually that it is snowing during this time. And it also doesn't appear to be any dispute factually that the contractor, who is the co-defendant in this thing, T. Meyer Landscape LLC, is at least present and plowing in the parking lot at the time or about the time, near the time that the accident occurs. And T. Meyer plows that parking lot under a contract that requires plowing when there is 2 inches of snow accumulation, and also requires, important for this case, shoveling of the sidewalk. They're envisioning that shoveling after only 1 inch of accumulation, arguably a somewhat higher standard, or perhaps more urgency to clear the sidewalks than the remainder of the parking lot. The plaintiff testifies that he notices some snow on the ground and falling from the sky, or at least before he goes into the store, and photographs that have been submitted with the pleadings indicate there is snow on the ground and the tracks of a cart going into the store, indicating at least that no one shoveled that sidewalk, presumably at least between the time he went into the store and when he went out of the store. As defense counsel has stated, the plaintiff's testimony is that he encountered slush, and that when he encountered that slush or stepped on it, that he slipped and fell to the ground, causing the injury. And the question is, should D&W, because there is no question that there was direct notice here. At least plaintiff doesn't say that he himself, after he went inside, said to the D&W manager, well, it's getting pretty slick out there. You better get someone out to shovel that thing, that there was direct notice. But there are indirect indicators that D&W knew or should have known that snow was accumulating. What were those indirect accumulators? Well, obviously the fact that it was snowing in the first place would have been the very first uh, uh, indicator to the store manager and other employees as they arrived that snow was falling outside. And in their comings and goings in the store, and also interactions with customers, they were aware, or should have been aware, that slush and snow were accumulating on the sidewalks outside the store as well. What else could have placed them on notice? Well, perhaps the arrival of their snow plow crew, whether that was before or going on at the same time that the plaintiff fell in this case. It doesn't appear to be any controversy that T. Meyer arrived on the scene with their snowplow truck and began plowing the parking lot, presumably pursuant to their contract that required that plowing when 2 inches of snow had accumulated. And thus, the facts undisputably show that snow had accumulated and had been accumulating for a period of time before this fall occurred. The facts also show that even though the plow people were out there and beginning to plow in the parking lot, the plow people didn't immediately get out and shovel the sidewalk, even though the contract envisions them shoveling the sidewalk, and arguably the 1 inch accumulation on the sidewalk being lower maybe puts a little more urgency on the shoveling of the sidewalks. They didn't engage in that, instead, for whatever reason, choosing to plow the parking lot first. And of course, the other unknown there is how soon after the snowfall and the store's opening that they got down there. After all, the contract doesn't specify that the plowing needs to be started until 2 hours after the store's opening, giving them a window of time to arrive, i.e., it doesn't have to be plowed down to the asphalt prior to the store's opening, showing that the store would envision at least sometime during snow accumulation when its customers might have to negotiate some of the snow. Now, it's also notable here, plaintiff was parked in a handicapped lot. Well, even though plaintiff doesn't testify that any physical limitations, that is balance or dizziness, caused the fall, nonetheless, it certainly puts the business owner on notice here that some customers with limitations on their mobility, perhaps limitations on balance, using walkers, etc., may park there, and thus arguably emphasizing the importance of clearing that sidewalk area between the handicap slot and the store first. So, in short, and further, there is some testimony that the weather records will corroborate what doesn't appear to be disputed, that snow was falling at the time of this incident. The court certainly understands defendant's misgivings about it's a situation, as my dad might have said, where you're darned if you do and you're darned if you don't. If you notice some snow falling and you start to remediate it, that is, you get your snowplow service out there and they start to plow it, well, then everyone's gonna say, well, of course you had them out there, you knew snow was falling, you had notice, and thus you're liable if an injury occurs. And then, of course, the flip side of that, if you don't do those things, then you're going to get hammered for not being reasonable in protecting your invitees on your premises. However, I will note that framing it as kind of a binary, this or that, decision is a bit of an oversimplification, because at the end of the day, plaintiff's counsel is correct in stating, well, a manager certainly has some options, one of which might be to get out there and shovel that area, or sweep it, or clear it himself, or assist the customers as they're negotiating the snowy area. A second might be to lock the doors and explain that the store is going to be closed for an extra hour while snow removal and safety things are attended to. And of course, a third option might be racing out into that parking lot, knocking on the door of the T. Meyer landscape vehicle and saying, hey, I got customers walking in and out. Do you think you could scrape off the sidewalk with a shovel first and then plow the parking lot second? Because I think that's an area of greater risk, because almost every customer, of course, has to come in or out of one door or another. So there are multiple fact questions here that bring this within the province of the jury in deciding that with regard to notice, were reasonable steps taken within a reasonable amount of time. Unquestionably, it's a reasonable step to hire a snow removal service, very prudent, but of course it doesn't begin and end there. One cannot just hire such a service and say, okay, I've done my duty for winter and I'm done with it. But rather, in addition to that, a premises owner expecting invitees, especially invitees who may suffer from disabilities and things of that nature, as of course visitors to a grocery store might be older, has that highest level of duty to protect them against foreseeable harms. Here, the slush, snow, ice that had accumulated over some period of time, undoubtedly what created a foreseeable harm, and thus created a fact question for the jury. So the motion for summary disposition is denied, and I will request, Mr. Gross, can you send me an order to that effect?
I would be willing, respectfully, Your Honor, it's defendant's motion and he usually does it, but if the court wants me to do it, I would be happy to do it.
Would you rather send that to me, Mr. Rizzo?
I'd be honored. I will do that, Your Honor. Thank you.
Very good. Well, thank you. This was well briefed and, it throws, some questions we've been looking at least in the whole 30 plus years I've been practicing law in this state is, what are we going to do with the fact that we got snowy winters and people slip and fall during those times. So questions that we'll probably be arguing about when we're all in nursing homes someday, hopefully well protected against such accidents. So wishing you